4B, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine.
Yes, Your Honor.
All right, court is calling 2023 CR 10986, State of Texas versus Leslie Myers. Could I have parties announced for the record for the state?
Alexandria Boggs for the state.
Defense?
George Schaefer for defendant, Your Honor.
And are you Leslie Myers?
Yes, Your Honor.
And am I pronouncing your last name correctly?
Yes, ma'am. Thank you.
Sure. Did you review, just one moment. All right, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Leslie Dawn Myers who was placed on deferred adjudication in 2023 CR 10986 for the offense of assault, family second offense on December 13th, 2023 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Violating condition number 24B, on or about the 15th day of November 2024 in Bear County, Texas. The defendant, Leslie Dawn Myers, did then and there find herself in contact with Benjamin Guild and threatened, assaulted, or verbally abused said person in violation of condition number 24B.
To that, how do you plea? True or not true?
True, Your Honor.
The state waives the remaining allegations, Your Honor.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of 24B, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to proceed with your plea of true to 24B?
Yes, Your Honor.
Court will find 24B true. All right, is there a proposed agreement?
There is, Your Honor. The proposed agreement is that she be sentenced to 2 years TDC.
All right, so has she done anything on probation other than threatening someone?
She said a bunch of negative UAs, Judge.
I finished my fifth class as well, and I did my 90 and 90, and I did about 3 or 4 meetings weekly. I was about to start my community service.
All right, and Benjamin
Guild.
Guild, is he the complainant in this case?
He is, Your Honor. And he's present in the courtroom.
All right, does anybody want to call him as a witness? Because I don't think that, okay, I don't think that 2 years is appropriate in this case. And let me explain to everybody why. It's because she's on probation for assault against the complainant. And then 24B is, I don't know, assaultive language or threats against the same complainant. So I don't understand why it should follow the agreement. That's what I'm asking.
Judge, I'll call him as a witness.
All right. Mr. Gill, if you can come forward, please.
Ms. Myers.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Benjamin Holmes Guild.
All right, defense.
And you are the same person who was the complainant in the original case that she was put on probation for?
Yes.
And you are the same person who has alleged that on November the 15th of 2024, she committed another assault against you, correct? Now, at the time, were y'all drinking alcohol? She's not supposed to consume alcohol. You're aware of that?
Correct.
Same thing with you. You're not supposed to consume alcohol. And that's because you're on a probation yourself. And what was the nature and extent of this argument? What happened?
I'm not sure of the details, to be honest. Call the details.
You were arguing with her?
It's probably mutual.
She was arguing with you?
No, it's probably more me than.
You understand that the state is recommending a sentence of 2 years Are you amenable to that, or would you accept that?
Define amenable.
Well, are you happier than the court saying, no, I'm not gonna accept that offer and sentence her up to 10 years?
I would rather that not happen. I would rather she get less than 2 years.
How long have you and she been together?
On and off for. She's been down here for 8 years. We've been acquaintances for 20 years, 20+ years, 25 years.
And I'll pass the witness.
All right, any questions?
I have no questions.
All right, thank you. All right. This is, if there's nothing else from either side, this is what the court is going to do. Court is finding
24B.
24B true. The court will grant the motion. The court will find you guilty, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Benjamin Gill. I'll request the therapeutic community for you, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand? Right. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you. All right, the court is going to call 2024 CR 0150 State versus Amanda Drummond. If I could have parties approach, please. All right, and for the state,
Jason Garahan, you're outside of mine.
for the defense? Defense,
On the record, your name? Oh, Bob Hicks.
and are you Amanda Drummond?
Yes, ma'am.
All right, you entered a plea bargain agreement. And according to the plea bargain agreement, the state is recommending deferred adjudication. You're charged with possession of a controlled substance penalty group 1 gram to 4 grams. The court ordered a TAP evaluation before sentencing based upon what I reviewed in the stipulations. Have both parties had a chance to review the TAP evaluation state?
Yes, sir.
Defense?
Yes, Your Honor.
Any objections to the TAP evaluation?
Nothing from the state law. None from the defendant.
All right.
She seems to be highly motivated for treatment.
All right, anything you wish to say on behalf of your client?
Well, Judge, according to the TAP evaluation and the Tacoma evaluation, she has had a pretty rough life, part of which is occasioned by her drug problems.
Mhm.
And part of which is the fact that her family has basically disowned her.
All right,
She
and
has
I'm
had
sorry,
a-
just one moment. And state you may be excused.
Thank you, Judge.
All right, you may continue.
She has a friend who is pretty much her sole support.
Mhm.
And she, as it says in the TAP evaluation, is very high. She wants treatment. She knows she's not going to be able to kick this stuff on her own, especially given what she was using, which was heroin daily, meth daily, and a phenomenal amount of alcohol daily. And the materials provided indicate that she is recommended for treatment and she's eager to take that treatment.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, make sure you keep your voice up so that the court reporter can hear. All right. So do you have any children?
I do, but they're all grown.
Okay. All right. You're not going to be released today because what I'm going to order is, Ms. Abrams, I'm unaware. I don't know if felony drug court has started openings or no. All right. All right. So this is what I'm going to do. Because one, the reason why I ordered the TAP evaluation is I want you to be successful in this probation. And I see that there are some drug issues that are happening. So we want to make sure that you have all the tools you need to be successful. In this courtroom, to be successful on probation, communication is key. If you ever feel as though you want to use or life is just hitting you and knocking you down, you can pick up the phone and call your probation officer and tell them, hey, I think I'm going to use. This is what's happening in my life. They're not going to send me a violation report saying revoke her. All violation reports come to me. And sometimes I will have compliance hearings where I have people come in to say, hey, what's going on? So I can hopefully get you back on track. And of course, there are some things that I can't get you back on track. If somebody picks up maybe a violent offense, I keep an open mind about everything. But for that, maybe I'm just going to sign a motion and say, hey, motion to revoke. But if there is an issue with your drug use, which is what we're trying to address, you got to do your part and we'll do our part. Okay. So what I'm going to do, Ms. Abrams, in this case, I'm going to place her on probation, 6 years deferred adjudication. Here's the thing about that 6 years deferred adjudication. If you complete everything early and you're doing great, the probation will send me a notice saying, hey, can you let her off probation early? She's got everything under control. She's doing great. And if that's the case, then I'll probably let you off early. You understand? So even though I'm saying 6 years deferred adjudication, whether you're on for 6 years or not is completely in your control. There's going to be regular reporting by Zoom or in person. That means you have to report. And usually it's once a month. All right. If you need to report more than that because you're trying to stay on track with your sobriety, just let probation know. They'll make adjustments. Okay. There's going to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. So you can get a job, but not as a babysitter, or you can't babysit, you can't work as a home health care provider, okay? There's going to be regular random UAs, and the UAs is where they test you for drug use, okay? I'm going to want field visits 1 time per month until further notice. Now, felony drug court is a great program. They're not going to be available to even consider accepting you till the beginning of February because of funding. I always tell everybody, talk to your legislature about getting them funding. So, Ms. Abrams, we're going to do a referral to felony drug court. And then I'm going to follow the recommendations of TAP evaluation. I want felony drug court first because they'll be able to address the drug issues plus the mental health issues. But we can also do a referral to DDRF, which is what they're recommending. If for some reason she's not accepted into that and she can't get into felony drug court, we'll bring her back and we'll consider another placement for you, okay? I just don't want you out in the world with not any support. I'm going to want 120 sober meetings and 120 days upon release. And let me just see if there was anything else that was asked in your plea bargain agreement. All right, probation, is there any, there's going to be 200 hours of community service restitution. Do you have any grandchildren?
I have one.
And what's their age?
She's 2.
All right. And are you in contact with your family?
I have contact with them.
All right. So let me just tell you, sometimes people want people to babysit. You're not in the condition yet to be babysitting, right? But what I will do is I'll deduct 100 hours of your community service restitution. And I'm going to order that you complete parenting classes. That's to help you when you are clean and sober and you want to be around your grandchildren. How far did you go in school?
10th grade.
All right. And then I'll do another 100 hours if you obtain your GED or some sort of trade school certificate. So I believe that community service hours, sometimes helping the community, is you getting your GED, you getting good, stable employment. So You need to complete your parenting classes. I'll deduct 100 hours off of that. And probation, if she obtains her GED or trade school, that'll be another 100 hours. If you don't want to obtain your GED or in some sort of trade school, then you're going to have to do 100 hours of community service. And sometimes that means picking up trash off the highways and byways. You understand? Yes.
I've been to a trade school. I have my CDL.
Okay.
So, I mean, I've already been to trade schools before.
All right. Well, I tell you what, if your license is in order and you present that to probation, then I will deduct 100 hours of community service restitution.
Okay.
All right. Probation, is there anything else? I'm sorry, what? Yes. And MIC supervision. And that's a specialized caseload so they can address any issues you have. Anything else, probation? Is there anything else you need from the court in order to be successful?
No,
I'm
ma'am.
sorry, Judge.
Yes.
I apologize. Mr. Hicks mentioned that she lived in Karnes County.
Ah,
She lives in Karnes County. However, she understands that she's gonna need to live here until,
all right. So are you okay with living in Bear County? All right. So she's okay with living in Bear County. All right. So counsel, I need your client to sign the trial court certification of defendant's rights to appeal.
I didn't do this before. And where it says defendant. I got you there.
Right here.
Yes.
Thank you.
That
All right.
explains why I didn't sign one of those before. Actually, I did. I
Oh.
have one.
All right. Did you review the document with your attorney? It's called Trial Court Certification of Defendant's Rights to Appeal. It's this document
Yes.
that you just signed.
Yes, ma'am.
Did you review that with him?
Yes.
Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, as I said before, communication is key. If there is an issue, let your probation officer know. If you feel that they're not addressing it, if the courthouse is open, I'll be here. You can come in and address it with me, okay? All right, if you need anything, let us know, all right? You're welcome. Probation is going to go over conditions with you.
Crystal D. Molina stands before Judge Stephanie Boyd facing a serious financial crime, misapplication of fiduciary property valued between $2,500 and $30,000, with restitution totaling $110,000. From the opening moments, Judge Boyd establishes complete control of the courtroom. She confirms Molina understands the charge and the punishment range, up to 2 years in a state jail facility and a $10,000 fine. But what comes next builds the emotional weight of the hearing. The state waives other allegations and proceeds on a single count, recommending community supervision yet demanding restitution. The plea is no contest, but Judge Boyd quickly issues her verdict. Sufficient evidence exists, and she finds Molina guilty. The moment of judgment is not delayed. Instead, the pressure intensifies. Judge Boyd orders a PSI hearing and delivers a direct instruction. Molina must bring at least $5,000 in restitution on that date. The command lands heavily. The defendant quietly acknowledges understanding. The judge further restricts Molina from ever working in positions involving handling other people's money, a clear sign of how deeply financial violations break trust. Judge Boyd's approach is precise and uncompromising. There is no deferred adjudication, meaning Molina's record will reflect the conviction. The courtroom atmosphere tightens as consequences settle in. The defendant may avoid jail time through community supervision, but financial responsibility now determines her future. Can she produce thousands before her sentencing? Will repayment influence the final outcome? By the end of the exchange, one message is unmistakable. In Judge Stephanie Boyd's courtroom, restitution is not optional. It's the first step toward accountability.